to the parties that this hearing is being recorded, as they all are, and it's being live streamed.
Okay. Live streaming is a new part to me, but that's okay.
Well, they aren't closed to the these hearings are not closed to the public, so if the town chooses to live stream them, it's not inappropriate.
Oh, no, I understand, yeah. Similar to if you were in person and you would just walk in.
That is correct.
But hopefully we don't get Teams bombed. I know sometimes you get some random visitors, so.
We do have protections in place where no one actually has the team invite other than the individuals here. The end where they can see it is a view only. We wouldn't even know if someone had jumped on.
Oh, no, for sure. No, I was just being a little funny, but no, I kind of assumed that.
And thank you for pointing out that you can see my reminders. I will move those off so that you can only see the agenda for today.
Okay, I think that's good then. We'll open this hearing at 1:02. I think that's good then. And this is a one-person hearing. It is a preliminary hearing. And my name is Lana Yakimchuk, and I am the chair. I'm the panel for the hearing today. And so we'll begin with introductions, and let's just introduce the two administrative staff who are online with us today. So go ahead, Ms. Hipkin.
Yes, good afternoon. My name is Jody Hipkin, acting as co-clerk for this hearing.
And
I'm Alicia Pollitt, working alongside Jody Hipkin.
Okay, thank you. All right. As I said before, there are minutes being taken. The hearing is recorded. And so conduct yourself accordingly. I'm assuming that will be just the same as always. And we'll begin with introduction of the complainant.
So in this case, I think the roles are reversed, so I don't think I'm the complainant.
Oh, is that right? Who is launching this appeal? The assessor?
Well, the appeal was initiated because the documents did not come in by the timeline. So we did list Codger, or however you say that, Codger Developments Limited, Kara Bryan ULC as the complainant, and the Town of High River Assessors as the respondent.
Okay, so let's get this straightened out before we do anything else, because in this case, for the merit hearing, when you have the merit hearing, of course, the assessor will be the respondent. Ryan is the representative for the complainant, and the assessor will be the respondent. But the person or the group who asked for the preliminary hearing with the issue, with the complaint that the payment was not on time, would then be the assessor who's saying that, or the assessor would be saying that the payment is not on time, and you're the one who's defending this, Mr. Dalrymple?
Yes.
Okay. So in this case, it is actually reversed. It's going to look very unusual to you. We're going to call. So we will state in the decision ahead of time that the complaint was launched by the people who will be the respondent during the merit hearing. Does that work for you?
Can I just clarify that the payment was received on time? It was actually the documentation that came in after the deadline.
Yes, so it was documentation that was not received on time.
Yeah.
Okay, or that's the complaint is that the document was not received on time.
Yeah.
Okay. All right. Thank you for correcting me there. So we'll begin with you then, Mr. Donner.
Okay, thank you very much, Madam Chairman.
Just introduce yourself for now.
Okay.
We just need an introduction for the record. Sorry.
All right. My name is Stuart Dalrymple. I'm the appointed assessor for the town of High River.
Okay. And for Ryan?
My name is Arunan Sivalingam on behalf of the respondent with Ryan ULC.
Thank you. We're all going to be very confused from here on in, I'm sure, but we'll do our best. So I'll just read in the issue is was the complaint received late, and this concerns roll number 265300, and is it Kaiser Developments? Mr. Sipalingam, do you know
I believe it's pronounced Kaiser, so I think we'll just go with
Kaiser. Okay. Okay. So we'll call it Kaiser Developments Limited on 1500 12th Avenue Southeast. Is the address. And the assessment was for $3,635,700.
Yes, I believe that's correct.
Okay. Okay. Write that down. So in that case, we will begin with you, Mr. Dalrymple. Oh, do you have somebody there with you? And perhaps we should include them as well. Sorry, go ahead.
I do. Thank you. This is Brandon Garner. He's our other assessor for the town of High River, who's also attending today.
Okay. Okay, now go ahead, Mr. Dalrymple.
Thank you, Madam Chair. Jody, would you mind putting up our submission up on the screen? So yeah, there we go. Thank you very much. So Jody, if you can be our scroller through the document, that'd be awesome. So if we just scroll through, so this is a table of contents with our complaint submission. If you would mind just scrolling through those, please, Jody. This is our guide for the contents of our submission. And just keep scrolling, if you would mind, Jody, to page. Yeah, there we go. That's good. So this is just for information. As you mentioned, Madam Chair, this is not a merit hearing. It's a preliminary matter hearing. So this is just information regarding the subject property regarding the camp property it is and its respective value. So it's just included for information. Scroll down, please, Jody. So it's a preliminary matter hearing to determine the validity of the complaint, as mentioned in page 4 above. So it's the items mentioned are the completeness of the complaint form, if this complaint is invalid, and the complaint was submitted after the filing deadline. So presenting at the hearing today is myself, Stuart Dalrymple. I'm accredited assessor and the appointed assessor for the town of High River under the appropriate regulations as stated. And then Brandon Gardner, of course, he's with me today. He may have some comments to offer as well. So as we scroll down the page a little bit, we just want to address some.
Can I just interrupt? Are you going to? I am just seeing the scrolling on the side in the right-hand side column. I'm not seeing it on the screen, and I wouldn't mind if we could share it. Yeah, yeah. I mean, I could follow it on mine, but I think you'll have better access. So if you can share the screen, that'll work better. Otherwise, I'll move into my.
Okay, so you're not seeing the.
I'm not seeing it as a shared document. I'm just seeing it in as you're scrolling through on the right-hand side, the same way you would. It's just the thumbnail.
Oh.
Well, it's a little bit bigger.
I'm seeing expanded. Maybe it just has to be maximized. I don't know.
I'm Balan Sharma.
There we go. That's it.
Okay, perfect.
Okay.
Yeah, thanks.
Thank you for pointing that out.
No problem, but thanks. That's good. Let's go ahead.
Okay.
All right. Okay, go ahead.
Yes.
Okay, thank you. So before we get into the complaints here, get some references to specific legal terminology, because these terms do come up in our submission. So the term must or required, the legal definition of that statement is it's a compulsory or mandatory requirement. So there's no discretion. When the legislation states must, there is no discretion. These things must occur. As opposed to may is a permissive term that grants discretionary directives. So it's allowed but not required. And then shall is to impose a legal duty or obligation. So it's very, very closely aligned to must. But for this submission today, we'll be talking about must quite a bit. So in our opening statement, this preliminary hearing is being conducted to determine the validity of a complaint regarding the subject property as stated. The complaint was submitted after the due date and not accompanied by the required fee, which is statutory requirements. Information presented in this submission shows that adequate notice was shared with the agent, both publicly and privately, regarding the stated deadline for the complaint, which according to legislation, to be valid, must be accompanied by the fee before the deadline stated. Information regarding the complaint deadline, the complaint fee payable, was publicly available as well as being clearly communicated to the agent representing the owner. So that's our opening statement. So if we can just move on to some significant legislation that's pertinent today for this preliminary matter. Looking at section of 462 of the Municipal Government Act, and this statement is significant in its mention today. So section 462 states a complaint must be in the form prescribed in the regulations and must, again, be accompanied with the fees set by council under section 481(1), if any. So that's the first statement highlighted in red. If Jody, if you could scroll down a little bit, please. And then under section 461(2), the applicable filing fee must be paid when a complaint is filed. So on this page, with reference to this legislation, must is the word that's used. So Jody, could you please scroll down? Also, according to matters relating to assessment complaints regulation 218 AR 201/2017, matters before the assessment review board panel, section 3.1, if a complaint is to be heard by a panel of an assessment review board, the complaint must complete and file. The complainant must complete and file with the clerk a complaint form set out in Schedule 1 and pay the appropriate complaint fee set out in Schedule 2 at the time the complaint is filed. I'll just repeat that. Pay the appropriate complaint fee set out in Schedule 2 at the time the complaint is filed, if in accordance with Section 481 of the Act, a fee is required. And under Division 3, further down the page, gets reference to the fee under Section 12.1. The fees payable by persons wishing to make a complaint or be involved as a party in a hearing by a panel of an assessment review board panel are those fees set out in Schedule 2, which are shown below in Schedule 2. So if you please scroll down, Jody, that'd be great. So here's just the assessment review board complaint. I've split it into two pieces because to put it on one page, it gets to be too small. So this is the complaint. It just reference to the property, basically. Just to go with this. So this page refers to Section 1, 2, and 3, and then on page 11, it makes reference to Section 6 and 7. And Jody, I wonder if you could zoom into that page. Is that possible? Just zoom in a little bit, make it look a little bigger. Oh, perfect. You just move it. There we go. Perfect. So I know this is small print, but just I want to read this because this is kind of going to come up in our submission. So I'm just going to read what it says in the middle there. It says under important notice, your completed complaint form and any supporting attachments, the agent authorization form, and the prescribed filing fee must, there it is again, must be submitted to the address with whom a complaint must be filed as shown on the assessment notice or tax notice prior to the deadline indicated on the assessment notice or tax notice. Complaints with an incomplete complaint form, complaints submitted after the filing date, or completed without the required fee are invalid. So I just think that's an important statement to make, and it's listed right on the assessment review board complaint. So Jody, if you could please scroll down to page 12. And if you could zoom in again, please, into the highlighted area, that would be great. Thank you very much. It's a bit blurry. Hope you can follow me with this one. It states, if a complaint fee is required by the municipality, it will be indicated on the assessment notice. Your complaint form will not be filed and will be returned to you unless the required complaint fee indicated on your assessment notice is enclosed. So when I read that, just for perspective, when enclosed means it's included, like they're submitted together. Okay, so Joy, if you please go on to the next page. This is just the agent authorization form that's been completed to represent, so Ryan ULC can represent the property owner. And just to scroll to the next page, just for point of reference later on, the date this agent authorization was signed, I believe it looks like April 2nd, 2026. So that's the only point I want to make there. Scroll down to page 15. This is the 2026 property assessment notice. And just to point out this information about the property, legal information, its respective assessment, and the complaint date to file a complaint, as noted on here, is May 12th. It's just near the bottom. Thank you, Jody. Just to show you that the date is clearly stated on the assessment notice. And if you could please scroll to page 16. Let's see here. Excuse me, sorry. We can probably just go past this page. Thank you very much. So this is page 17. Is there any way we can get that to fill the whole page and still be legible, Jody? If that's possible, that'd be great. Zoom out a little bit. Zoom out a little bit so we can see all of the columns and rows.
If you press F11, it will also kind of just make it your entire screen will be the PDF.
Oh, perfect.
Then you can maybe even close that left-hand panel of all the pages. That might help. I don't know how you do that though.
Can everyone read that?
Yes, yes, it's quite clear. Thank you.
Awesome, thank you.
Just before you go ahead, this is made up as part of your argument. So the notes in the column are all notes that were applied in preparation for this hearing, right?
Correct.
Okay, go ahead.
So yeah, it's a good question. Thank you for asking that. It's with reference to I think I asked you to scroll by it. I don't know if you want to go there or not, just to make reference to it. The emails referred to, if you go to page 4 of this submission. Thank you, Jody. There we go. So on page 4 there's reference to the emails. So these are mentioned in this assessment review board communication. So on page, if you scroll down a little bit there, Jody. Oh, yeah, it's a bit on both pages, isn't it? So these emails here, they're referenced on page 17, which we're about to go over. And then the details of these emails, if we can go back down to 17, please, Jody. Sorry. There we go. Thank you. So I'm going to make reference to these emails. Now, in our addendum to this submission, the emails specific to this correspondence are stated on the addendum pages. So each of these rows refers to an email communication between the clerk of the Assessment Review Board and APT Calgary. So we can, if you want, you can make reference to these emails. We can do it on the fly, or you can make reference to it after. But this is a summary of the communication between the clerk of the Assessment Review Board and the respondent. So I'll just kind of go. Does that make sense? Is that okay with you?
Yes, that makes sense. And I actually have already done an awful lot of that comparing, and I pre-read this prior to your arrival here. So just if you just go through what's on the table, that would be perfect.
Okay, thank you very much.
Yeah.
So there are 1, 2, 3, 4, 5, 6, 7, 8, 9 points of communication between APT Calgary and the clerk of the Assessment Review Board here at the town of High River. So just now with the submission on the 11th of May 2026 of 4:58 from APT Calgary, Grace, and the clerk of the Assessment Review Board, Jody Hipkin. So in this communication, these were submitted for 8 appeals as listed, and they're on that email communication is on page 22. So, and as we were preparing for this, it kind of dawned on me that the only the fees, to my knowledge, and will be evidence later, only the fees were submitted on the 11th. And so, and I'll just go back to page, if you can go back up to page 8. Sorry, Jody. Perfect. And just under 462, just to reread this again, a complaint must be in the form prescribed in the regulations and must be accompanied with the fee set by council under section 481(1). So it's not, this isn't really mentioned in this complaint, but just a note, reviewing this information, if the legislation states that the complaint must be accompanied by the fee or vice versa, just a note here, just to note that these 8, for these 8 roles, only the fee was submitted on the 11th. Right? When the legislation states the fee must be accompanied by the complaint, to be valid. So I guess it didn't kind of dawn on me until we were putting this together that if the legislation says the submission and the fee must accompany each other, and we've gone over this in these first few pages many times, it states the complaint and the fee must be one and the same. And that's going to come up later in our conclusion as well. Anyway, that's just a point to note. On the 12th of May at 10:40, from the town of High River to APT Calgary, then a receipt was issued for the submission of the fees for the 8 rules above. And then we kind of out of time out of there. Sorry about that. On the 12th of May, and now bearing in mind the 12th of May is the deadline for the submission of a complaint here at the town. At 8:49 a.m., APT Calgary, Grace, sent the first batch of assessment complaints to the town of High River Legislative Services. So then these complaints then are these first 4 representing batch 1 and mentioned in the email in the addendum on page 24. So these are accompanying, these complaints are following from the fee submitted on the 11th, but as again noted, they're not accompanying, so the fee is separate. I guess the note, right? These complaints are filed separate to the fee. On the 12th later on in the 12th of May at 8:55, from APT Calgary, Grace, to Town of High River Legislative Services, they received batch 2, so 3 more rolls on that at that time, and then an email was sent from the clerk. Well, at 2:55 on the 12th of May, the same day, the clerk of the Assessment Review Board, Alicia Paulette, sent an email to APT Calgary. APT Calgary is stating the complaints had been received for 7 properties, but 1 was missing. So the clerk had asked APT Calgary that fees were paid for 8, but to date they don't receive 7 submissions, and asked if that was forthcoming. So there was an email later on the 12th at 3:01 from APT Calgary to the clerk of the Assessment Review Board, Alicia Paulette. An email was sent stating that the complaint would be forthcoming, and they're waiting signing of the authorization form. And just to go back, and it's probably a moot point, but just to go back to what page is that? The agent authorization form. Oh, here we go. On page 14, at the bottom of the form, just as a note, the agent authorization form was signed on April 2nd. So that's just a note, right? Maybe it was misfiled or something, but it was certainly signed before May 12th. This is a note. So it's 3:58 on May the 12th. The clerk of the Assessment Review Board, Alicia Paulette again, emailed APT Calgary, Grace, just to remind the agent that the complaint needs to be submitted before 4 p.m. because that was, and I'll wrap up with the deadline date, the time. Just to remind APT Calgary that the notification of complaint needs to be received by 4 p.m. So clear communication, you can see there's clear communication between APT Calgary and the clerk of the Assessment Review Board. Later on the 12th at 4:34 p.m., there was an email from APT Calgary, Grace, to Alicia Paulette, the clerk of the Assessment Review Board. The submission was finally sent for the specific role that we're talking about today specifically. and it was received after the 4 p.m. deadline. That's on page 28 of the addenda. And then on the following day at 11:53 on the 13th of May, there was a communication from the clerk of the Assessment Review Board, Jody Hipkin, to APT Calgary, Grace, notifying that because the complaint was received after 4 p.m., it was considered an invalid complaint. And so that will be taken to, that's why we're here today, to talk about that particular matter. So that kind of wraps up the communication. But you can see on this page there's lots of continuing and ongoing communication. So everyone's on the same page. Everyone's aware of rules filed, fees filed, which complaints have been received after the fees were paid the following day. So there's no suggestion that 4 p.m. wasn't the deadline, right? I think was a clear communication that we want to make sure the clerk of the Assessment Review Board was very active in communicating that the submission needed to be submitted by 4 p.m. May 12th. So I guess let's turn to page 18. This is from section 6 of the complaint form. And just to read this, about the filing fee and the complaint. If the municipality has set filing fees payable by persons wishing to make a complaint, the filing fee must accompany the complaint form, or the complaint will be invalid and returned to the person making the complaint. So this is a regular statement echoed in all the communication that we've been reviewing today, stating the significance of the complaint and the fee being filed together. And on matters for complaint, it gets reiterated again. I think we covered this before. If a complaint fee is required by the municipality, it will be indicated on the assessment notice. Your complaint form will not be filed and will be returned to you unless the required complaint fee indicated on your assessment notice is enclosed, not received the next day, not received sometime, not received before the deadline. It says enclosed. So I can only surmise that means with. And again, references to legislation pertinent to the complaint form, and the fee states they must accompany each other. So regarding communication, it's a position of the town of High River that we clearly state, while it's not on the assessment notice and it's not on the complaint form, in the town of High River, our policy, if you will, is to encourage property owners or agents to file their complaint before 4 p.m. If you look at the bottom of the page, sorry, Jody, on the next page, page 19, and highlighted in blue. Now, just to note also, this newsletter is sent with every assessment notice, every one of them. And so we state the dates, the schedules are on the side. We ask people to be prepared when they talk to us. The requirements of filing an appeal, highlighted in red. The communication is clear. And on the bottom, in all caps and highlighted in red, appeals must be received before 4 p.m. May 12th, 2026. So the town is doing its best to state when they must be due and how it must be received. And again, if you go to page 20, this is a copy of the Town of High River website. And this is the top of on the property assessment portion of our website. It clearly states May 12th, 2026, 4 p.m., final complaint deadline. So the town's endeavored to make it clear why the deadline is May the 12th. For the town of High River, where the property owners are encouraged and agents are encouraged to make sure that the complaint and fee, which must be filed together, are received before 4 p.m. on May the 12th. this is clearly done so that the town can ensure that whether you're an agent representing the owner or a property owner who has no understanding of this process, a property owner can come in, and if they come in before 4 p.m., the clerk of the assessment review board will help them make sure that the complaint form is completely filled out properly, and the fee is included with the complaint, because that is a complete and valid complaint. So the decision to make sure these complaints are valid for all property owners, the town wants to make sure that if someone has a valid complaint, we want to make sure that they are heard. We want to make sure so that we don't to not make sure that the complaint is completed properly or accompanied by the appropriate fee, or setting them up for failure. So we encourage property owners and agents to file before 4 p.m. so we can ensure that those complaints are properly completed and processed. So just on page 21, just to wrap up, the assessment review board complaint and the question today, and just add for all those properties that were submitted on the 11th, just as a note, the fee for the complaints was paid one day, and the complaints were received the following day, which is not in accordance with the regulation. But with regard to the specific role, as mentioned as a subject property, we're saying because the fee in this case was paid after 4 p.m., as communicated from the clerk of the assessment review board to APT Calgary, was stated that that appeal not valid because it was the complaint, while the fee was received on the 11th, the complaint wasn't filed until after 4:34 on the 12th, May the 12th. Again, it's a moot point. While the reason stated the complaint was late was because the agent authorization form wasn't completed, it clearly was completed on April the 2nd. Just from referencing our earlier review of that. The deadline for the submission of the complaints and their associated fees was clearly advertised. While it's not on the assessment note, on the back of the assessment notice, and it's not on the assessment review board complaint, it's clearly communicated by the town to all property owners with the newsletter, with advertisement from the webpage, and it can clearly be seen in the ongoing communication between APT Calgary and the clerk of the assessment review board. Obviously, there was active communication between those two parties, and everyone knew at hand there 4 p.m. was the deadline. So it was no mystery. The town is clearly stated 4 p.m. so that this process can be completed properly and for the benefit of all the property owners. So legislation clearly states when the required fee does not accompany the complaint before the deadline stated, the complaint is invalid and must be dismissed. And that is our recommendation as the respondent in this situation. Thank you very much, Madam Chair.
Thank you very much. Mr. Silverlingam, have you got any questions that you wish to address to the assessor?
Yes, Madam Chair. All questions to the board.
Okay.
I guess it's kind of interesting because they're scrolling up. Can we go near the top? I guess this starts at 5:35. I don't know when this actually starts on here. If we go up a little higher, can we just kind of maybe go to the beginning? Sorry, I'm trying to follow this on two different documents and page numbers. I'll just try to find this quick, actually. Hold on. Make this easier for everybody. Okay, can we go to 532? Basically, actually, let's do it this way. It's page 8 on the actual document, even though this full document of 500 pages is larger. So if we just go to page 8. There we go, perfect. So this is from the MGA section 460, and as was read out, a complaint must be in the form prescribed in the regulations and must be accompanied with the fee set by council. So, but we would agree that the fee was paid on the 11th, which is 2 days. Sorry, it's the day before the appeal deadline. So I guess first question is, you would agree that the fee was paid on May 11th, and the second question is, we would all agree that the deadline date is May 12th.
Is that a question?
Yes, ma'am.
Would you like to answer that, Mr. Donovan?
Yeah, I'd agree that the fee was paid on the 11th and the deadline was the 12th.
Okay, and so I guess in kind of pointing out this section, the hang up here is on the word accompanied. But we would agree that paying the fee and filing the form would be two separate processes, because to pay the fee, you have to pay through Visa, and that's a whole different process than emailing. You have to, like, for all intents and purposes, go through a payment process, and that's separate. And I would assume that's why Grace, my colleague, tried to do it early, because she knows that a payment has to be processed, it's Visa, etc. So you'd agree that the administrative filing process of a form, I guess, and the payment are two separate processes, because you've got two different things that can't really be done together. You've got to pay separately and make sure that's done, and then file. Would you agree?
We agree that there are two different processes, but at the town here we require both the payment and the complaint fee to be completed at the same time. Like it says in the legislation there that they need to be accompany each other. While the different processes, the complaint form and the fee can certainly be paid the same day.
Okay, so I guess when you're highlighting the word must and accompanied, at the end of the day, to file an appeal and follow the regulations, a complaint form has to be filed along with the fee. So we'd agree that both those things were done. So the fee was filed on May 11th. The town accepted that happily. And secondly, with respect to the complaint form, although provided the next day, it was still filed on May 12th, which is the deadline date. So the two requirements, the payment of the fee and the filing of the form to file the appeal, were done within the deadline date, and I'll get to that on the notice of assessment. I guess the difference of view here is the town expected that to be done by 4 o'clock.
So a couple of things to answer to this. The inquiry period is 67 days. So we're talking this process is being completed at the end of a 67-day length of time. At any time during this can be completed. Like it doesn't have to be completed at the last day. And furthermore, you're right. I agree with you on one word here, accompanied. It doesn't say it can be the fee and the complaint can be separate. It can be required the next day. And on this statement in the 462, it has two musts in there. The complaint must be in the form prescribed in the regulations, and the second must be accompanied with the fee. So it clearly states that the fee and the complaint have to be received together. Even later on, it says enclosed, right? So it's the statement is they're one and the same. It's to make it a legal document. And again, that's why at the beginning of this presentation, submission, we refer to the word must. It's fairly significant with regards to this matter.
Okay, so not to belabor this too much, I'll just say, yes, it does stay accompanied, which means
you can address that in your presentation.
Yeah, that's fine.
You've asked the question. I think we can go ahead. Do you have another question?
Yes. Can we please move to can we go to the next page, 536? So I've already asked this question. I really was going to say that we would agree that the fee was paid and the document received. So can actually move past this page. If we just want to scroll on to the next page. So this is the assessment review board complaint form for the property. So you'd agree, at least as the first part of it, that the information has been completed, like it's been filled in.
Yeah, I agree with that.
Okay, then we go to the next page, please. You would agree what's required has been completed here as well. I would note that the last part, it's for clerk use only, so obviously we wouldn't fill that in, but the signature is there, dated as of 5/12/2026.
Well, the complaint form is filled out, but the fee is, but there's like the boxes aren't filled out here. So I'd agree that the complaint is dated the 12th of May. And signed, yes.
Okay, yeah, because again, like pointed out, the box at the bottom is not to be filled out by the person filing, right? This is for the clerk use only.
Correct.
Okay, and then last point here is just to state, so it's dated 5/12/2026. You would agree May 12th, 2026 is the formal deadline date for High River for 2026.
Oh, it's May 12th, but for High River, it's May the 12th at 4 p.m.
Okay. If we want to go to the next page. Okay, so this is the matters for complaint. So when looking at this page, you'd agree that it does not state anything with respect to time. So it doesn't say 4:30, 5 o'clock. I can't find anything with respect to an actual time with respect to the filing of a complaint.
In the highlighted section, it does say your complaint form will not be filed and will return to you unless the required complaint fee indicated on your acceptance notice is enclosed. So at the same time.
Okay, but this just speaks to the fee, right?
Correct. But it's saying the fee must accompany the complaint.
Okay, so I won't go back to that because we already asked about that.
Right.
If we want to go to the okay, if we just want to scroll to the next page. Okay, so we've gone through this. If we want to just keep going, the next page. So I'll just dwell on here for a second. So we would agree what this is the assessment complaints agent authorization form, typically referred to as the ACA, correct?
Yeah, that's what this form is. Yeah, agent authorization form. I agree with that.
Okay, and we'd agree that it's signed by the ratepayer.
Yeah, I agree with that.
Okay, if we can go to the next page, please. Okay, so this is the property assessment notice. So this is the notice of assessment that would be sent and received by the property owner, correct?
Correct.
Okay, and then just a few things here. The mailing date, it states as March 5th, 2026. We would agree with that?
Yep, I agree with that.
Okay, and then notice of assessment date. Sorry, that's not on to go to. That's also there. If we just kind of go near the bottom of the page, it states there final date to file complaint, and it says May 12th, 2026. You would agree with that?
That's correct.
On this form, does it state a time at all that you can see or point to?
I did mention that before, that it's not on here, yeah.
Okay, but this is the formal, like, lack of a better word, like, legal notice to the ratepayer that this is how much you're being assessed, and if you want to contest it, you have to file by this date, correct? Like, this is sent every year. This is the formal notice of assessment. You would agree with that?
I just want to add to, and I didn't quite say this before, that to my knowledge, there's nothing in the regulations that state that the town can't state a time.
So you would, agree that stating
this is a legal document, but I believe there's nothing in the regulations that states that the town can't be specific about the time for the benefit of the property owner and the agent. That's just my comment.
Right. Okay, so then a question arising from that is, so there's nothing. You're saying there's nothing in the regulations. So would it be fair to say then it would be your interpretation that the municipality could add time as an additional requirement that they could impose?
Oh, well, we did, because there was a newsletter that went out with every notice, and it was clearly advertised as well at 4 p.m.
Okay, we want to go to the next page. So this box you've highlighted in red, this really is regarding the complaint. So it talks about, it states here, to file a complaint, complete a complaint form, submit it along with the correct fee. Complaints must be processed on or before the final date of complaint on the front of this notice, or the complaint is not valid. Now you'd agree the final date of complaint, and we just referenced the previous page, that the date it states is May 12th, 2026, correct?
Could you repeat that question again, please?
Oh yeah, apologies. So in this box here, or what you've highlighted in red, the second paragraph there, it states essentially to file a complaint, complete a complaint form and submit it along with the correct filing fee. Complaints must be processed or on or before the final date of complaint on the front of this notice. So my question was, you would agree that the final date of complaint on the front of this notice, as we just walked through, was May 12th, 2026?
Yeah, I agree. It says the May 12th is the deadline, and it says that the complaint must be submitted along with the appropriate fee. Yeah, okay. I agree with that.
Okay, and then if we want to just go to the next page. Okay, so this is kind of the page where I guess the kind of the correspondence and kind of what's transpired has been kind of put into table form to lay out dates and times. So I'll just go through this quickly with you, again, not to belabor some things. So in the first column there, we have the date as 5/11/2026, or May 11th. You would agree with that?
Yep.
And then it looks like it's from APT Calgary, and then it's to the clerk of the ARB, and the notes are the fees are submitted for 8 appeals. So there's 8 appeals submitted, and then the property that's under, I guess, part of this preliminary hearing is part of one of these 8, correct?
Correct.
Okay, so it's received on the 11th. The next day on May 12th, so the second column, 5/12/2026, 10:40, you'd agree at 10:40, at that time, this shows that a receipt for the appeal fees paid as above was received. So that means the payment was received and a receipt was provided to confirm as such, correct?
On the following day, yeah.
And then this May 12th agreed, not to belabor it again, but we would agree that 5/12/2026, May 12th, that's the deadline date. So it's still within the date of the deadline is on the notice.
Yeah, the deadline for the fee and the complaint to be submitted together, yes.
Okay. So then we see on column 3 or line 3 at 8:49, it appears that from APT Calgary, a batch 1, so with 4 complaint forms, so the kind of forms that would accompany the fees were provided at 8:49, and then it appears at 8:55 an additional 3 are provided for batch 2. So 7 of the 8 are received by 9 a.m. in the morning, correct? Or before 9 a.m.?
Yeah, I agree that they're received after, but they did not accompany the fee.
Okay, I won't kind of belabor that again, but okay, but we agree the fee was paid previously. Okay, so then so for the so the 5th line, I guess, column 255, it appears that the clerk sent an email stating that 7 of the 8 complaint documents have been received and the fees have been paid for 8, and it appears, like without having the email right in front of us, that the clerk is kind of wondering about the last one, correct?
Yeah, correct.
And then at 3:01, so shortly, like about 6 minutes later, from APT Calgary, a response is provided saying it's being worked on and they hope to provide it momentarily, kind of thing.
Yeah.
Okay, and then at 3:58, it appears the clerk responds. So it's 3:58, so 2 minutes before 4 o'clock, and sends an email stating a complaint needs to be received by 4 p.m. So 2 minutes before 4 p.m., it appears an email's sent saying this needs to be provided in 2 minutes. Is that a fair reading of what this is kind of summarizing?
I'd say that's a communication from the clerk saying, you said you were going to send it. We're just letting you know it's an email. You can send it right away, right? It wasn't. We're not babysitters of the town. The clerk's just reminding the agent that there's a deadline.
Okay, and then at 4:34 is when the submission is filed, and again, we would agree it's filed on May 12th, 2026.
Yeah, I agree. I won't beleaguer the 4 p.m. You know my stand on that.
No, I know too. So the only additional thing I'll ask, and it's just to state, but from a definition of a day, the day would end formally at 11:59. I know the appeal has to be in by 4 High Rivers, I guess, what they're requesting, but we would agree that the day, May 12th, would end at 11:59.
So that's a good point, and I thank you for reminding me about that. Now, the town states 4 p.m., and that's because we want to make this process fair. If we let the deadline be 11:59:59 for an agent representing a property owner who's very familiar with the process, that means for the regular person on the street, they can't come in the office, they can't walk in off the street and say, we'd like to file a complaint. We would be giving the agent special treatment, special consideration over and above the regular walk-in person who simply wants to file a complaint. So again, that's why to keep it fair for everyone, we stay at 4 p.m., 30 minutes before our office closes, so that the complaint can be, the clerk can ensure it's a valid complaint and accompanied by the appropriate fee. So that's why it's clearly 4 p.m., so there's not special treatment for anybody who decides to file after the 4 p.m. deadline.
Okay, so maybe I could just ask some additional questions arising from that. So I guess the first point is, you would agree that the document received at 4:34, it was not received at 11:59. So it's not like the document was received closer to the 11:59. It's really more, we're talking about a difference of half an hour, not 6 minutes before 11:59. Correct?
It's still after the 4 p.m. deadline, though.
No, I know. I'm just saying, but in terms of kind of making that argument that you're saying, we're not talking about a difference of we snuck it in a minute before. There's a difference there. The second point is, a question if I can ask is, based on the notice of assessment, and we could go back to that, but I'll just refer to it, is many municipalities throughout Alberta, as part of the regulations and being familiar with doing this, there's different means allowed to file your complaint. So one is you can file the complaint in person, correct?
Correct.
The second way is you can mail it in, correct?
You can, as long as the complaint fee and the complaint are enclosed together.
Correct. And then the third way is through electronic means, which was done here. So is it really a matter of unfairness or providing different avenues to file a complaint?
The town's position is we want to be fair to everybody.
Okay. Okay, so we're on page 544. So if we want to just maybe go to the next page. So I guess with respect to this page and some of the similar pages that we kind of went through, just to make it clear again as a final point, I guess. But we would agree that the fee was paid. There is no issue about not having the fee received and paid, correct?
The fee and the complaint must accompany each other according to legislation.
Okay, sorry, but not to be difficult, but we would agree that the fee was received and paid, correct?
Sure, that's correct, but my standard legislation says must accompany. It even says it above the filing fee must accompany the complaint form.
I know. So the reason why I'm asking this, so it's very clear that I'm not trying to be difficult, is what's bolded here. It says preliminary matters to determine if the complaint is valid. 1, non-payment of the complaint filing fee. So I have to make it very clear for everyone here and the board chair that the fee was filed, because I don't want it to come off that payment wasn't received. So that's the reason why I asked the question.
I never suggested that. No, you're correct. The fee was paid. I'm not suggesting it wasn't.
Okay, yeah, no, and I wasn't trying to say that you were saying that. I just wanted to be clear. That's why I was just highlighted this page. Okay, and then if we can go to the next page. So with respect to this is the assessment newsletter that you had stated, if I remember correctly, that the town kind of puts together and provide and sends out, correct?
Yeah, this is a letter sent with every assessment notice.
So this is more like a mailer. You would agree that this is not like a legal document such as the notice of assessment. This doesn't have to go with the notice of assessment. This is just provided as an additional accompaniment to it.
Yeah, we're just trying to make sure that everyone's aware of the important dates and deadlines and dates for appeal and requirements.
Okay, fair. So if you want to just go to the next page. And again, we just agree, this is the town of High River webpage. This is not like the Government Alberta website, etc. This is just a shot taken from the web page that speaks to property assessment, I guess.
Yeah, that's correct. And if to add to your comment too about the electronic filing of a complaint being a possibility, I believe to do so they have to go by this page as well. So they're going to see that information as they're on the way to an electronic filing as well.
Okay, if you want to go to the next page. I guess that's all my questions for now.
All right, thank you. I just have a couple of questions. The one question is the 4 o'clock time limit. You said that it's a policy of the town. Is this a policy that has been passed through council? Has it got official status as a town policy?
I don't believe so.
Okay. And secondly, when you receive electronic payments as a rule, are they always sent in tangent with each other, or tangent to each other? Are they always sent in sync so that you're receiving your complaint and your payment at exactly the same time?
My knowledge, they're generally received together.
Okay, so your definition of together would be
same day or at the same time, like one and the same. It's a good question, Madam Chairman. It's just like what it says in the legislation about either accompanying or enclosed if it were to be mailed. So at the same time.
okay. Thank you. Does anybody need a break, or shall we go on with the next presentation?
I would say I'm okay either way.
Okay. I think we're probably good to hear your presentation, and then we'll just take a 5-minute break before we hear closing statements. Okay?
Sounds good.
Okay, go ahead, Mr. Silverlingo. Go ahead.
Okay, so I believe Ms. Hipkin is kind of struggling with the document. Is that correct?
Yes, that is correct. So I will do my best to follow your directions.
No, yes, and I appreciate you doing that. So I'll try to just do it that way since I'm not kind of going through it myself. So I guess we'll just kind of go through this. We want to just go to the next page. If you want to just keep going to the next page. Keep going. This is just a preliminary notice for this hearing, so it's not a big deal. So we can pass this. Perfect. And then we just want to stop here. Okay, so I'll just kind of read through this summary of testimony evidence that myself as the respondent will speak to. So as we kind of heard here today, it appears that the reason for this preliminary issue is with respect to the complaint that was filed, along with a total of 8 from our firm that was filed on May 12th from Ryan ULC on behalf of various ratepayers that we represent as part of the appeal process for property assessments. So the complainant submits, because we're reversed here, that the complaint was filed within this statutory complaint period, and that the municipality's position, namely that the complaint is invalid, is solely because it was submitted after 4 p.m. on the final dates. Oh, looks like something had to pop up. Sorry about that. And it will be our position that this time frame deadline is unsupported by the overall spirit of the governing legislation. At first, we had thought that maybe the payment of the fee was an issue, but I think we've clarified that doesn't appear to be the issue. It appears to be the time in which the submission was received. So I'll just read here point number 1. So Ryan ULC will show that the Municipal Government Act requires that a complaint be filed on or before the complaint deadline shown in the assessment notice. The legislation is directed at the deadline date itself and does not prescribe a specific hour by which the complaint must be received. I would argue if it did so, knowing that we have, top of my head, maybe 200 different municipalities throughout the province that would separately undertake property assessments, we could imagine what that would look like if there was different times throughout. So our reading of the legislation is providing a deadline date so that the ratepayer is given the opportunity to contest an assessment that they may not agree with, and that's been outlined, and we'll walk through that. It does not prescribe a specific hour by which the complaint must be received. Had the legislation intended to impose an earlier closing time deadline, it could have done so expressly. The absence of any reference to a 4 p.m. cutoff is significant. A time-specific deadline is a materially different requirement from a date-specific deadline, and it should not be implied by administrative practice or municipal convenience. Again, because from our reading, the spirit of the legislation is to not be prohibitive or punitive. Secondly, Ryan will show that the matters relating to assessment complaints regulation, thank you, defines what is required for a valid complaint. Specifically, Section 3 is the operative provision addressing complaint validity. It requires that the complainant completes and files the complaint form and pay any required fee at the time of filing. If those requirements are not met, the complaint is invalid. So I know that there was some discussion on terminology here of, the English word accompany. So our view and reading of the legislation is there's 2 important aspects of filing an appeal at the onset, which is completing the form, the valid documents, and then filing the fee. So the idea of hanging on the word to say that those 2 elements are tied at the hip to each other would be an extremely detailed reading of the wording, and I would submit that that is not the intent of it. It's to ensure that those 2 pieces are completed, and they're completed within the deadline. so that A, the fee is paid because that's part of the process and allows for the function and administration of the assessment appeal to operate, and the accompanying administrative documents to ensure that the right person signs, etc., and identifies what the issues are and who's complaining. I would note that it does not contain a reference to any type of time-based deadline, municipal office hours, that the complaint be physically received before the close of business, or invalidity arising merely because filing occurred later in the day on the final complaint date. From our view, it would not prejudice the going toward the merit hearing, the respondent, to come to work on the following day and have the materials to review. So from our point of view, the time-based deadline would only serve to make it more onerous, actually, for a ratepayer rather than, I would assert, to assist them. Thirdly, Ryan will show that the clerk has no authority to add conditions not found in the legislation. Sorry, I want specifically one person. I would just say Ryan would state that the administrative function does not have the authority as being more administrative to add an additional requirement such as a time-based deadline. The overall role we would view it as is to receive, process, and refer complaints in accordance with the legislation. But imposing additional validity requirements that do not appear in the Municipal Government Act or the regulation, we believe would act against the interest or the spirit of the regulation itself. Accordingly, the question of validity must be determined by reference to the statute and regulation alone, not by reference to an internal office time or administrative practice that has not been incorporated into law. And I would point it out, as was brought up in questioning, specific to the High River bylaw, there is nothing within the bylaw that states that we have in front of us or has been made aware that a deadline is formally in place. A time-based deadline is formally in place in addition to the date-based deadline. Ryan will show that the principles of fairness and access to the complaint process support a liberal interpretation of the respective regulations and statutes. If we can go to the next page, please. Okay, assessment review boards are quasi-judicial bodies and must act fairly. Where legislation creates a right of complaint, any ambiguity in filing requirements should be interpreted in a manner that preserves rather than defeats that right, absent clear legislative language to the contrary. It would be prejudicial and contrary to procedural fairness to deprive a complainant of the statutory right to be heard on the merits based on a filing time rule that is not expressed in the governing legislation. The next point, Ryan will show that the municipality should be required to identify the source of its asserted 4 p.m. requirement outside of itself. At the preliminary hearing, so this is kind of a viewpoint, but we would just state that to identify where this would be found, including the sections within the Municipal Government Act, the specific section within matters relating to assessment taxation, any bylaw relied upon, the wording in the assessment notice, any published filing policy or instruction relied upon. So I think in that case, it would appear to me that the reference would be the web page, but as was kind of pointed out, there was different aspects pointed out with respect to the MGA and MRAC, but that was more regarding the fee and ensuring that the documentation is provided, but there's nothing with respect to how onerously the deadline date and time should be looked upon. So, as stated there, if no express legislative or regulatory provision can be identified that imposes a 4 p.m. deadline, the municipality's objection to validity should fail and not be the source for kicking out a valid complaint. It will be our position that the assessment notice is central. The wording of the assessment notice should be determinative, especially as that is the formal legal document that's provided to a ratepayer that states, this is your assessment, and based on this assessed value, this is the taxes you will be paid. that is a legal requirement. One cannot receive a notice and say, I've received an assessment. I don't like the taxes. I'm not going to pay it. I mean, you're going to get penalized or the government's going to go after it. So to me, that is a legal document. And with respect to that document, it states there the final date of appeal is May 12th, 2026 for the current year. It does not state if you would like to complain, you must do it by 4 p.m. It provides you the various methods to do that. And I believe that is also part of the spirit of the legislation, to provide ratepayers the ability to have various means to be able to contest if they have an issue with their assessment, because you're looking at something where under our overarching kind of democratic framework, ratepayers should have the ability to contest when they're taxed if they believe it's unfair. And I believe that's the spirit of that. And that is paramount, to not prejudice someone based on smaller formalities. So the board should therefore examine whether the notice refers to a complaint deadline date only, expressly states anything regarding the time frame of when the appeal should be received, and contains any wording capable of supporting the municipality's interpretation in this particular instance. So if you want to just scroll down a bit more, thank you. So I'll just kind of read from here. The principles of statutory interpretation, the modern principle. So I've used myself as a complainant, so I guess technically the respondent submits that the legislative provisions in dispute in this proceeding must be interpreted in accordance with Draker's modern principle, as affirmed by the Supreme Court of Canada in Ray, Rizzo, and Rizzo Shoes Limited, 1998. As articulated by Draker and adopted as a preferred approach of the Supreme Court of Canada in Rizzo, the modern principle requires that the words of an act are to be read in their entire context, in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament, as Sullivan on the Construction of Statutes, 5th edition, explains. The chief significance of the modern principle is its insistence on the complex, multidimensional character of statutory interpretation. It requires that interpretation begin with ordinary meaning, but not stop there, obliging interpreters to consider the total context of the words in every case, no matter how plain these words may seem upon initial reading. So the next paragraph here, Rizzo principle, absurd consequences must be avoided. In Rizzo and Rizzo Shoes, 1998, Ikabuchi confirmed as well-established principle of statutory interpretation that the legislation is not intended to produce absurd consequences. The Supreme Court held that even when the literal text of a statute might support a particular reading, that reading must, if we can go to the next page, please, be rejected if it would produce results that are illogical, inequitable, or inconsistent with the scheme of the Act. Sullivan on the Construction of Statutes sets out the propositions comprising consequential analysis. It is presumed that the legislature does not intend its legislation to have absurd consequences. Absurd consequences are not limited to logical contradictions, but include violations of established legal norms and widely accepted standards of justice and reasonableness. And whenever possible, an interpretation that leads to absurd consequences is to be rejected in favor of one that avoids absurdity. I'll read the next part here. Quebec versus Corp Notre Dame de Bonsecours. Strict construction of taxing provisions. In Quebec, Communauté Urbaine versus Corp Notre Dame de Bonsecours, the Supreme Court of Canada addressed the proper interpretive approach to municipal taxation legislation and confirmed a principle of direct and critical application to the present case. Where a taxing provision is ambiguous or where the scope of a municipality's authority to impose a tax is in doubt, the ambiguity must be resolved in favor of the taxpayer. The court affirmed that taxation statutes are to be construed strictly against the taxing authority where the authority to impose tax is not clear. The burden of demonstrating the existence of a valid taxpayer power rests on the municipality. If we can scroll down a little bit here. So I'll just read this part here. The Act as a whole, defined terms must be read consistently throughout. Sullivan on the Construction of Statutes further established that governing principle that a statutory word or expression can be fully grasped only in relation to the whole of which it is a constituent part. Take the totality of the governing legislative documents for property tax appeals in Alberta. The deadline date is provided for the whole province. Municipality-specific deadlines, if meant to be in the spirit of legislation, would explicitly state such provisions. Considering, again, off the top of my head, we're talking about over 200 or 250 plus municipalities. In the absence of clear wording imposing a 4 p.m. deadline, the complaint should be found valid. The committee respectfully requests that the board reject the municipality's interpretation that a complaint filed on the statutory deadline is invalid, on the statutory deadline date is invalid merely because it was submitted after 4 p.m., whereas every other required part of the process, the fee and the form, were properly fulfilled and provided, and instead find that the complaint was validly filed within the meaning of the governing legislation. Okay, so I'll just, instead of kind of reading this part again, I'll go, if we can go to the next page, please. Okay, we can keep scrolling. So I'll just kind of go, if we stop here, these are the emails. I think they are summarized in the complainant's document. So I won't really just kind of hammer this again, but again, this is kind of the email back to show that there was the 8 properties and the appeal fee, and that they were paid on Visa. And we can see here they were paid on Monday, May 11th, from ABT to the clerk to confirm that. So if you want to just continue to the next page. So this is the receipt of payment. So we've kind of gone through this. We'll just pass through these. If we want to stop here for a second, just to confirm that the receipt date, as you can see here on this page, 2026-5/12. So the fees and money have been received and confirmed as of the deadline date. I'm going to continue to the next page. We can continue, keep going here. This is just more of the backup to the table we discussed. We can continue. Continue going, please. To show that this is the backup to show the documents for batch 1 and batch 2. Keep going. Keep continuing. Continue past this. Okay, yeah, continue. Yep, continue. Okay, if we just go down a little bit here. Okay, so it looks like this email here between the clerk and ABT just says, "Hey, Grace, you got your voicemail. Want to share the deadline is clear on our website." Also emailed 1 to confirm was going to be issued by 4 p.m. So this is the next day, Wednesday at 11:53. If we just go down a page, and it looks like this was just shown after the fact as part of this email, from what I can tell on the correspondence. If we want to continue down, keep going past this, please. Emails are all scattered out. Continue. Okay, just pause here quick. We've already gone through this. This is the appeal package that's submitted. I think we've confirmed through questioning that everything here was properly provided, so we can go past this. This is the tax notice. We've got this as well. We can go past this. Okay, well, let's keep going. This is just the appeal package. Next page, please. Next page after this. You can go past this as well. Okay, sorry, just give me 1 second because I don't have control of scrolling. I'm going to try to make this easier for everyone and try to just see where we can jump to in the document going off of my original. So I'm going to just skip the MRAC part because we've kind of already highlighted that, and maybe what our difference of opinions are there. I'm just going to it's going to be page 159 of my document. So if we just look at the bottom corner of mine, we'll see what that is. So a little bit more. Yeah, exactly there. So it's 122. So we have to kind of play with some math here. Okay, perfect. We just scroll down a little bit here on this page. So just note here, notice of assessment date. So this is section 308 of the Municipal Government Act. So it states here, an assessor must annually set a notice of assessment. The assessor must set additional notice of assessment dates for amended. Sorry, that's not what I want. If we just go to the next page, and it just talks about what should be on that notice of assessment, the notice of assessment date, a statement that the assessed person. So we see point C here, a statement that the assessed person may file a complaint no later than the complainant deadline. So it doesn't say the deadline is a specific time. It just says that it has to provide to the complainant that there's a deadline, that date within which, if they have any issue with the assessment, that there is recourse for that. So if we just continue going on here. So the point here is in this kind of section of the MGA regarding property assessment, we don't see anything specific to a time deadline, but it only just speaks to a deadline being provided. Okay, so we're going to keep going down from here, keep scrolling. Sorry, and I'll kind of go to my document here to see where we can skip to. Okay, so if we want to go to page 174 of my document, or the respondent document, on the bottom right-hand corner, yes. So this is just like a car board order from 2012 where there was a similar situation. So I'm just going to walk through it briefly, not go through it word for word. So if we want to just go to the next page. So for the Coles notes, essentially a similar situation where in 2012, the town of Okotoks, the complainant was wanting to file on the deadline date, and then when they arrived, the doors were closed minutes before even the 4 o'clock deadline was posted. The complainant did their best to then provide an email and provide the documents that way. In a similar vein, a preliminary hearing was held to try to dismiss the complaint. So if we go down the next page, continue down. Continue. Okay, sorry, I'm going to go back a bit because I had some notes in my own document. Can we just scroll back up again? Sorry. Okay, so if we can just stop here. So there's paragraph 8 for this decision. So on Monday, May 14th, Ms. Keegler, so this is the complainant who was trying to submit the complaint, received an email from Ms. Linda Turnbull, Municipal Secretary and ARB Clerk, confirming receipt of the email and the complaint documents. And on May 23rd, similar in this case, advised there would be a jurisdictional hearing. Paragraph 8. Ms. Keegler submitted that there was no intent to abuse the process, but simply a series of unforeseen circumstances led up to the filing of the complaint. Ms. Keegler informed the board that the procedures for preparation of appeals and the filing of complaints are administratively cumbersome and differ with each municipality in Alberta. And she just expressed her opinion that the complaint has become overly complicated. So I want to note again, in this case, it wasn't the day after the deadline. documents and the fee were filed on the same day. She had initially tried to do it in person, and when that didn't work, then provided everything by electronic email well before the end of the day. So we want to continue on to the next page. Sorry, I need to go back up again just to paragraph 9. This is kind of the hard thing when I can't go off my document. I just want to highlight this here. Paragraph 9. Ms. Keeler submitted that the slight delay in filing the complaint was a minor breach of the deadline that did not result in prejudice to the respondent. It was simply a matter of being a few minutes late in filing on the Friday afternoon. Again, this is within the deadline date. And then I'll just read paragraph 10 on that same page. Ms. Keegler cited the decision of Boardwalk, Reed LP Edmonton, City 2008, noting that the removal of a party's right to complain is a drastic consequence of a minor defect, and went on to submit that reasonableness, fairness, and natural justice should apply in the present case. In her closing submission, Ms. Keegler said that the discretion of the ARB should not be used to render an appeal invalid on a technical basis. Okay, and if we want to continue on to the following pages. Also, I'll read on paragraph 19 here. If I want to go to the next page. Okay, so it states here, because the date on the assessment notice did not stipulate that a complainant must be filed before 4 p.m. on, in this case, May 11th, the respondent was at liberty to file the complaint until midnight. Also, since there was nothing in the assessment notice that stated that complaint could be filed by placing in the drop box, Municipal Center after hours, the board finds that filing the complaint by email was a reasonable and effective way to meet the deadline. Again, within the time frames. If I want to go to the next page, continue on. Go to paragraph, let's go down a bit more, next page. Okay, we just stop here. So this is just following paragraph 26, just the smaller wording portion there. Section 3091C of the Act directs that assessment must be set a date by which a complaint can be made, and such date must not be less than 30 days after the assessment notice is sent. Sorry, I want to read the second paragraph. The newspaper publication required by Section 311 of the Act and the deeming provision for receipt cannot override the appeal rights specified in Section 3091C. The Act is clear that the date noted in the assessment notice must be a minimum of 30 days after the notice is sent and received. So the kind of key point here is that even any publication or additional supplemental information does not override the overall spirit of the right to appeal and have that be allowed for by any complainant, especially if they have filed within the specified deadlines and provided the fee. If we want to continue on. Just go near the end here. I'll just highlight there, as it says, the board decision in this case, by virtue of Section 23 of the Interpretation Act, the complainant had until midnight, May 18, 2012, to file its complaint. Accordingly, the complaint filed on May 14th was made within the proper time and is a valid complaint. Okay, so we want to just continue. Okay, to the next page. So here's just some notices of other municipalities. So just to point out, it's quite a standard practice that the legal notice of assessment, as an example, has a final date of complaint, and it has a date stated. It does not state anything with respect to the time it must be received or be completed by. If you want to go to the next page. The City of Airdrie is an example, same thing, just to highlight there's an actual deadline date specification only. If we want to go to the next page. We can continue on to the next page. Similar here on page 225 of 566 that we're all looking at. Again, a date-based deadline. If you want to continue on to the next page. City of Calgary, one of the large municipalities. We go down a bit. I think the deadline is there. You can see at the bottom, Assessment Review Board. Complaint deadline has a date-based deadline. I'm going to continue. So we can go through this. I'm not going to really have to highlight anything here. I think it's just to speak to kind of the Interpretation Act, and that's been referenced in other decisions. We can kind of go through this. I'll just follow on my own page here, just to make sure. Okay, just give me one moment. I'm going to just get ahead on my page. Okay, if we go to page 244 of my document. Okay, so let's start here. So this is another CARB hearing with respect to a preliminary matter. I want to go to the next page. Okay, so as you can see here, yeah, sorry, I took some other things. I might have other notes or things there. We'll see here with respect to this decision and this hearing, there's a preliminary issue of if the complainant had submitted the necessary disclosures within the time limit specified. So if we continue to the next page. So in this case, essentially, that was with respect to if the documents were received on time, or a courier company was used. So similar to the case before us, the information was provided the day of. It was a difference of, it was a, sorry, I'm getting a cramp. The deadline, similar here, was 4:30 instead of 4, but it was end of day deadline. The information was still sent the day of, but received shortly after that. And then as we can see, point D, section 22 of the Interpretation Act was put forward with reference to the days and what should happen with respect to a specified time frame. So we go to the next page. This is more just a decision I hope can be referenced. Similar to what was kind of provided before, that the deadline is really midnight, not suggesting that we would want to be submitting everything at 11:59, but a day ends at that point, and so with respect to looking at the deadline, that should be the overall view rather than an office or time-based deadline. So we can see that pointed out here. And if we go to the decision here, point 9, the board denies the applicant's review to disallow. So in our case, we would, from a merit perspective, the complainant's disclosure documents with respect to disclosure that were delivered on the stipulated date, but after the city's offices were closed. I can go to the next page. Point 12, the board notes the applicant's concern pertaining to the actual time of delivery of the package, but in the absence of any supporting evidence, assigns little weight to it. That's fine. So I want to read point 13. The board is persuaded by the complainant's case evidence that the ARB, not being a legislative body, does not have the authority to curtail a citizen's rights by way of setting arbitrary timelines which are not supported by legislation or the established case law. The board finds that the municipality's practice of marking the next day's date on the documents received after hours is totally discretionary. It may be convenient for the internal administrative purposes, but it's not supported by legislation or the case law. Paragraph 15, the board also notes that the delivery of the disclosure package a little after the office is closed for the day caused no prejudice to the applicant or any other party. And then it states in paragraph 16, in view of the above, consistent with the law and in the interest of fairness, the board finds that the complainant's disclosure package for the subject property was delivered within legislative timelines and thus admissible for the merit hearing. Okay, so I'll go to the next page here after this. Okay, we can go to the next page. Continue on. Continue on. I'll point out, if you want to just go to page 259 of, page 260 of my document. Okay, we just want to scroll down a little bit here on this page. So this is just like additional information provided by the City of Calgary as a reference point, where they say evidence must be filed by the deadline set by law. It must be received by 11:59. So even there, they state that the deadline date, the day ends at 11:59. Okay, I'm going to just skip ahead to something. Because other documents are some of the things we've already discussed. I'm going to just get ahead here. I can go to okay, if we go to page 2, oh no, my numbers are kind of mucked up. 285 of my document. Okay, so I'm just going to put in context. That's why I'm not going to go through these. These additional decisions pertain more to Section 295 preliminary hearing issues. So that's if request for information was not provided by a ratepayer and they filed an appeal, if their merit complaint should go forward. The spirit of why these are included is to show that in many of these decisions that rule in favor of the ratepayer, in circumstances ranging from the ratepayer not providing the information, providing it later, et cetera, the board places heavy consideration on weight on looking at the circumstances to see if the punishment, in this case, the kicking out of the right of the appeal, fits, for lack of a better word, the crime of not providing an R fee, etc. So in a similar vein, I'd like to point out, should the missing of the documentation being provided to the municipality at 4:34 instead of 4 o'clock merit the right for the ratepayer to have valid concerns regarding the assessment be kicked out. I would suggest if that would be the view, that would be the most harshest penalty that can be put forward, and based on a very, very detailed interpretation of the powers that an administrative body or tribunal could impose with respect to when they would like information received, and not in the spirit of the legislation. So we want to continue on to page, let me just get into my documents here.
If you're going to go on with Section 295 type stuff on fairness, I think we can probably read that ourselves.
No, I wasn't going to, yeah. So I'm not going to do that. Yeah, I just want to see if there's one little note to point out. I don't want to read it out.
Yeah, because that's
so of course, yeah. No, I don't want to do
relevant,
that.
And we can read it ourselves. Yeah.
I'm just trying to find where I had something here. One moment. just sorry, because I'm trying to go between the two documents where you guys have up. Just one moment. No, I think that should be all. That will be the conclusion of my presentation. I was trying to find something, but I don't think it's there.
All right.
So thank you.
Thank you very much. Thank you. Mr. Dalrymple, have you got any questions for Mr. Sapalin?
You're on mute, sir.
Yeah, thank you, Madam Chair. Sorry, I was on mute. Yeah, I guess a few questions. So my questions are specific to what the respondent just presented, or just overall questions, Madam Chair?
Questions concerning what he has presented here.
Okay. Let me think here. Let me just look here. With reference to legislation, when the legislation states, again, you refer to it in your disclosure, when legislation states something must be done, would you say that that's a mandatory statement?
So I think that's what I was trying to kind of highlight in the beginning part of my document and presentation is, I mean, words are used in the English language as part of legal and everyday discourse. The bigger reading I would suggest with respect to the case in front of us is you've got to look at the word in the context of everything else. So if you take one sentence and say it must be done like this, but then it's saying must be accompanied, I believe maybe you're going with respect to the fee in the document, it's yes, this must be done in order for you to file an appeal. But to file an appeal in conjunction with the municipality receiving the two documents that are part of the appeal, which is the appeal fee itself and the document, but trying to cut out just the word and focus on that stringently, I think can create, as was stated in the case law that I had referenced in the beginning, a potentially absurd outcome or reading of what the legislation as it is written is intended to convey as part of an administrative process to be undertaken as part of, in this case, a property assessment appeal.
Would you say that where legislation states instances where must is used, then obviously this process that we're going through today would take that into consideration, and that would sort of encompass what you stated as in the spirit of, or and would you say that the cases you're referring to are specific instances where someone filed after 4:34 or midnight, that while must is used, would you say that that must is as a term that we must follow, and that there are adequate processes in place to take into consideration unique circumstances? Would you say that that's fair?
Well, I think it can be simply put in with respect to when speaking of must, it's really speaking to the deadline. Like there's a deadline date. Within that date, you must file your complaint. Then we have the instances which I provided in the case law where, you know, there's been preliminary issues in other jurisdictions where someone submitted at 4:34 or at 10:40 or 11:36. The panels ruled that that was a very strict reading of the legislation and would be prejudicial to the ratepayer, and ruled that the complaint should continue forward. So I think that's exactly why it's there to say the must is with respect to the deadline and not any additional kind of pieces added onto that, which I would argue makes it more of a detriment to the ratepayer trying to go through this process as a regular citizen rather than the opposite.
No further questions, Madam Chair.
Thank you. I think you have both covered everything quite well here. I'm feeling comfortable. It's 2:51. Let's take a 9-minute body break and be back in at 3 p.m. And we will have closing statements. And I'm sorry, did you have a rebuttal, Mr. Dalrymple?
No, I don't. Thank you, Madam Chair.
Okay. So we'll come back and you give me your closing statements, and we will close the hearing. Okay?
Great. Thank you very much.
Thank you.
Thank you. Is Mr. Dalrymple there, or did he just forget to turn on his camera?
Yeah, he is, sorry.
Thank you. I think that's everybody. Yes. All right. We will begin with you, Mr. Dalrymple. Just make your closing statement.
Just a minute. Thank you, Madam Chair. Thank you for the opportunity today to discuss this matter regarding the complaint and the fee and the validity of the property before us. Just a couple issues. One, as we've kind of gone through about the fee must accompany the complaint. We're not, to our knowledge, that's not a usual process to have the fee submitted one day and the complaint the next. That's just a note on that one. The town stating the deadline to be 4 p.m. It's the town's position that while the respondent states that it's unfair to stay at 4 p.m. and to allow additional time to 11:59 for someone to raise a complaint about their assessment, the town stating 4 p.m. is given clearly. It's being communicated with the newsletter on the website, and clearly that's been understood in a communication with the respondent and Grace through APT. Certainly an awareness that 4 p.m. was the deadline. The reason 4 p.m. is preferred than 11:59 is it gives the clerk of the Assessment Review Board opportunity to make sure that the complaint forms are filled out properly and completely, and that they're accompanied by the appropriate fee. Adequate notice was given. The inquiry period in every municipality is 67 days. There's loads of time to raise a complaint, to submit a complaint and make sure that it's filled out appropriately. And legislation states that the fee must accompany the complaint. And if there's any issues regarding whether that complaint is valid or not, we have that opportunity today to present that as a preliminary matter. There's lots of discretion, but it's not out. The respondent often made reference to the spirit of the legislation, and that's fine. That's only an issue of interpretation. But from following sections of the Act with regards to complaint and the appropriate fee, when the language refers to the word must, and that's why the emphasis was made at the beginning of our submission that must offers no discretion. It's a mandatory statement, and if there's any decision to be made about the spirit of that mandatory request, then that's what these matters are for. That's what this arbitration process is for. Or was there extenuating circumstances? Why wasn't it filed on time? This process is very accommodating process, if you will, and we feel the town's being clear about the deadline being 4 p.m. on May the 12th, whether it's 4:05 or 4:34. We stated our deadline is 4 p.m. and so that's the requirement we have to properly help any complainant to properly fill out their form and submit their fee. So our position is specific to this property, that this complaint be made invalid, and that's our position on this matter. Thank you, Madam Chair.
Thank you, Mr. Dalrymple. And you, Mr. Sievelingam.
Okay, well, thank you again for your time today, and I will not try to just go over everything that's already been presented, but maybe just highlight our key points and objections with respect to our view of this preliminary matter. So as kind of established, it's very clear that the payment was paid. The visa was paid as a separate process. I would submit, if you're trying to reserve something or put your money down for something important, you typically want to pay first and confirm that things are good. So I would suggest in a case like this, knowing, again, the importance of an appeal deadline, typically the fees can be paid, maybe not on the same day, but I can't read my colleague's mind, but she probably wanted to pay on Monday to ensure that there was no issues with the payment, because then we'd be having another preliminary hearing about the fees not being received on time. So that was done, as pointed out through the evidence. Then Grace provided 7 of the 8 appeal packages in batches. And again, I don't know. I think maybe what if Grace was potentially having a bad day? She had mixed things up. She was trying to make sure that everything was ready for that one final appeal that we have in front of us here today, and kind of got everything in order and submitted at 4:34. This idea that there was ample notice, again, the website and the newsletter is separate from the notice of assessment, which is what the ratepayer receives. We, as the agents for the ratepayer, receive, and we see a deadline date. The idea around must, again, as I had stated before, is with respect to the deadline. It is not with respect to must regarding a deadline that is of a time in one municipality when the legislation is for the whole province. There are probably well over 200 plus municipalities. Off the top of my head, I can think of probably at least 100 secondary market municipalities that I deal with on an annual basis. I've been doing this kind of work appraisal, property assessment review, consulting work for well over 13 years. I have never come across a time-based deadline. In the past, years ago, there was a few that maybe had that, but for the most part, if we file our appeals on the day of, there's been no issue. Those filing times can be between 7 in the morning to sometimes at 5 or 6. Things happen. Obviously, like any responsible person, we don't try to do it at 11:59. In this case, I don't think that there's an egregious example of, for example, from APT Calgary, writing to the clerk at 3:58 and trying to sneak an appeal in. The correspondence actually shows that a fee was paid on the Monday, so the clerk was aware that, hey, it looks like there's 8 appeals coming in. Here's the fee. Then the corresponding documents were provided. Grace, advised that another one's coming. There was some back and forth. Only at 3:58 was it stated to her that the deadline's 4 o'clock. So imagine saying, well, you got 2 minutes, so get on it. I mean, I think the spirit here was from the APT Calgary perspective, trying to provide the documents and get them in within the day. And so the case law that was been provided shows that, it's really with respect to the right of the ratepayer in meeting the deadlines in the legislation. And in this case, it's not like we have a situation where we have an egregious abuse where, this is a repetitive example of late filing or something. We're really talking about something where it seems the letter of the law is trying to be used against the ratepayer to have their right to an appeal dismissed. With respect to this, we also agree in going through the documentation, because it wasn't really clear at the beginning when we had received this. I think everyone agrees and has seen in both parties' documentation. The fee was paid. It was received. A receipt was provided. The appeal documents were filled out correctly, so there was no error of, we're not sitting here saying, hey, there was an assessment appeal board complaint that the documents half filled in, it's wrong, we're missing signatures. No, there's nothing to that sort. It appears, from our perspective, the primary issue is regarding the time and when it was received. As noted in other decisions, and as we pointed out, it does not prejudice the respondent to receive this later. It was merely that they would have liked to have had it at 4:30. And again, as we've shown in other larger municipalities throughout the province, there is no stipulation around the time. They understand and look at the appeal deadline with respect to the date, and having that as a means to ensure that people follow that as I brought up before, as the spirit of the legislation. An additional point is, it has been stated, I think a few times, that, the town wants to do its best to ensure the ratepayer can be heard, and it provides these different means. I am in no doubt of that. I mean, and as I pointed out from our perspective, that is why in the legislation and through over the, again, 100 plus municipalities that I'm just kind of familiar with off the top of my head, there's various means to submit a complaint: in person, mail, and electronic correspondence. In this case, we've chosen electronic correspondence means. But in saying that, we are here today with respect to this preliminary hearing, wanting to toss out a appropriately filed appeal within the legislative requirements with respect to the information being provided accurately, correctly, and documented and signed, with the appropriate fee on the deadline date. And so we would request that the file and appeal continue forward to a merit hearing, as the penalty that's being requested here, from our view, and again, just to speak to why some of the 295 decisions were provided, just to show the spirit of those decisions backs up the premise that the punishment should fit the nature of the, I guess, the word's not going to be in English, the manner in which the, I guess you could say, crime was committed. Is this egregious? Is this in a repeated act of this particular ratepayer in this municipality? I would suggest that's not the case, and we don't see that. We really have to look at the weight of what is being asked here. And again, to really highlight in the legislation, because to us, the legal aspect here is the most important to consider. In the MGA, the MRAC, we don't see anything with respect to time, with respect to deadline. The language needs to be read in context of the legislation, as been pointed in the case law that I've provided. And the fact that the means of the deadline is to allow for the ratepayer to have their opportunity. And so if we get to a point where we start trying to look at small technicalities to take away that right, then how much farther are we going to go when it comes to other issues with regard to the complaint process? And I think that is why the legislation is written the way it is. And we've also tried to highlight how other municipalities act, again, because the legislation is Alberta based, it's not High River based. And so when it speaks to filing within the deadline as an overarching process oriented language, then that's what we should focus on. And as we've pointed out, other municipalities look at the deadline as within the day. And so I would requestfully ask that this preliminary matter be quashed, that the merit hearing be allowed to go forward, and the rights of the ratepayer to have their concerns be heard through the merit process be allowed, as they, from our point of view and looking at the required legislation and means to do that, have all been fulfilled, undertaking the proper mechanisms and channels, and we're done on time and completely. Thank you. I believe you're on mute, Madam Chair.
I muted myself because my dog was barking. Thank you. The hearing concludes at 3:15, and I thank you very much. You both presented really good arguments and provided me with plenty of information to make a decision. You will hear from me in the near future, probably well before the required time. So now I've made a promise, now I have to keep it. But anyway, there you go. I think we're all good. Thank you very much. And you will be hearing from us.
All right. Thank you everyone for your time. Have a great rest of your day.
Yeah. Thank you very much for your time, everybody. Have a good day too.
Bye-bye.
Yeah.